I'm very pleased to be able to be here to talk about this work which has been part of the AIC Visiting Fellowship, and I welcome you all to this presentation. I'm going to be talking about a study that was conducted with the Australian Federal Police, the AIC and University of Canberra. The report is not yet released, it's here being finalised. So I will talk to you about some principal findings, but there'll be some aspects of it which I will deliberately avoid because the detail required in terms of understanding the conceptual framework that we've developed is important. And it's quite lengthy in terms of trying to work out how to approach this subject in a meaningful way and to understand the nature of offending in Australia and then in a global context. And what we have is a small lens in terms of what was available for this particular study. So I just wanted to make that clear. The study, you can see my collaborators, Jenny, Russell, Adam, Alice and Sarah, and it's been funded by the Criminology Research Council. And so what am I here to talk about? Online child sexual exploitation material, referred to often as SEM, as an acronym. But of course, it's not how we talk about this topic in Australia. There's no real common language about this problem, and that in itself is a problem. So we have places that refer to child pornography, and I think that's something that really needs to be addressed, to associate child sexual exploitation with the idea of pornography, where pornographies are for liberally minded people perfectly acceptable. Then I think that's very wrong. We should be calling what it is we're looking at, or what is being examined as a subject, by clear terminology. So this is just a word cloud made of the words that needed to be defined for the purposes of this report. We have, as we're dealing with a cohort of Commonwealth Criminal Code Act offenders, we're talking about people who have been convicted of child pornography offences. But I stress the importance of referring to it as child sexual abuse material or exploitation material. The difficulty that we face nationally in talking about this topic is firstly a lack of data, but also this issue about terminology. Child abuse material, for example, for the Commonwealth, means non-sexual abuse of children that's depicted, but it's the term that's used for what is otherwise known as child sexual exploitation material in New South Wales. Some jurisdictions persist with the use of child pornography because that comes from some international law, and other jurisdictions in Australia have converted to talk about child sexual exploitation material, or some leave out the sexual. So it's an issue. So to talk about the scope of the particular study here, it's about telecommunications offences under the Commonwealth Criminal Code. Particular aspects of that are that we're talking about cases where a carriage service is involved, and that sounds rather quaint, but it really just means a service for the carriage of electromagnetic signals of whatever description. So it's become a very broad term to just talk about the fact that we're talking about digital media. So we have that as a narrowing aspect in terms of what we might be talking about, but then we have a very broad aspect in terms of how the Commonwealth defines this particular type of offending. So the Commonwealth, like other jurisdictions, talks about material that depicts or depictions or descriptions. So that includes things like written material, oral material, so sound, or it can include matters like cartoons or pictures that people have drawn, or artificially created images such as you might have with an avatar. So all of those things are included, as well as a requirement that there is or appears to be a child under 18 involved in the image, and that it requires also that there be a sexual nature to the image, and that in all the circumstances, so this is the thing that tries to restrict so we don't get everything, it's got to be offensive. So all of those sorts of tests are the things that come into play when we have examples of, a recent example in Victoria of artistic depictions, said to be artistic depictions of children. We've had numerous cases of that in Australia, and that coming into public contest about whether that matter is child sexual exploitation material or not. And ultimately it's the offensive test that decides that. But what it does do is create a very open definition of child sexual exploitation material. I'll come to that a bit later, because it seems to me that that's problematic, given that the maximum penalty for an offence such as this is 15 years imprisonment. To try to get some idea of the scope of the project and what we were looking at in context of what might be happening at a Commonwealth level generally, I had a look at the Commonwealth DPP information available about child sexual exploitation material prosecutions, as well as grooming and procuring prosecutions. They talk about charges, and the Commonwealth DPP has not had a consistent way of reporting this information, so I have a very schematic view of what's been happening. I have nothing for 2007 and 8, and I have charge information only from 2008 to 2011. I'm relating to these particular periods because that's the period of the study with the AFP data. So I just wanted to see, well, with the cohort that we have from a particular section in the AFP, how does that relate to the wider level at which Commonwealth matters are prosecuted? Because there's leakage. Other units of the AFP might be involved in prosecutions, or state or territory police may involve Commonwealth offences in prosecutions of people who are being dealt with for state offences initially. And that is significant because that deeply affects those who might fall within the Commonwealth's purview, those who may be detected by the Commonwealth, because the Commonwealth doesn't have primary responsibility for contact or physical sexual abuse matters. So that needs to be borne in mind when looking at the results of studies. It's what is the jurisdiction of the agency that's reporting this data to you? So anyhow, we have their charge numbers, and I just relate that to what we were looking at, which is this specialist unit that had that initial name, and this has now come to be known as the Child Protection Operations Unit of the Australian Federal Police, from March 2005 to December 2011. These are our numbers. So these are actual convicted people. So we've had to move from charges to actual convicted persons. So we have 152 persons convicted in the period as a result of investigations conducted by this particular AFP unit. You'll see that the majority are child exploitation material offenders alone. So that's the only charge that they faced. But what is important and worth pursuing in terms of greater investigation are those who are caught by Commonwealth investigation and found also to be involved in grooming or contact child sexual exploitation offences. And I would be suggesting to you that they're the people, as well as those who are also facing grooming charges, they're the people that we should be most concerned about, because they are actively seeking to engage children for sexual purposes. And what's interesting is to consider the degree to which that offending is precipitated by, encouraged by, or somehow associated with the fact of viewing the SEM, viewing SEM material. So we need to understand more about how these people come to a particular pathway of offending that ends up in seeking to procure or groom children for sexual purposes, and how many people are contact offenders who come in or out of the SEM offending field. This is not uncommon. All offenders are male in this study. There are reported cases of females being involved in SEM offending, but they're very rare. And that's a matter I'll leave for perhaps discussion as to why that might be so. I want to, though, before I talk about the age profile of the offenders in our study, just to start thinking about age and digital technology. Because I think there's a major problem with the way in which child sexual assault or child sexual exploitation offending is viewed when we apply a backward view of those who have offended in the past, or those who now offend but either grew up before the digital space became available, or those who grew up and transferred across to digital offending, or those who have just lived totally imbued in a digital landscape. So I think there's perhaps 4 or at least 3 different ages of engagement with technology that needs to be considered when we talk about offenders who offend in a digital environment. For example, if I was 14 and I'm not, I'd be born in 2000. 4 years ago I would have had perhaps ready access to smartphones. If I was 34 and I'm not, that is a period of when the real availability of digital technology to everyday people became possible. So I just invite you to think about that in terms of how we might need to segment the people that we are looking at as offenders and see whether they've come late to digital technology or whether they've been brought up with digital technology. So here we have the ages of the offenders. The italics indicates that it's less than the census expectation. So this is of males in the Australian census information. So the final column is percent in the census data. The percent of our offenders is shown in the 3rd column. And so we have a median age. The median age falls within the 36 to 45 year age group, which is not any different from studies elsewhere. Interestingly, though, the proportion of offenders aged 46 to 55 is perhaps slightly more than we might have expected, looking at other studies of offenders. So it suggests to me that we're looking at people who have come late to digital technology but have embraced it as part of their offending. The question might then be how much more likely are they to be contact offenders, or are they people who have simply transferred to digital offending anew without previously being involved in the sexual exploitation of children? We think about offender occupation. The 2 columns to the left, the first shows professionals, including 1 member of clergy, 2 members of the military, and other occupations that were listed as professions by the police in the recording of the data. The next one is people who are in employment but they're labourers or manual workers or in a trade. Others who were not identified specifically. Unemployment beneficiaries, so they are there. Students, they're there. The retired or superannuants, as we saw with the age profile, we might not have expected many of them anyway, but that's how they appear. Caregivers, sickness beneficiaries, and a couple were missing. So, like other studies, we've got a consistent idea of people who are male and who have, perhaps unexpectedly or expectedly, who knows, have high levels of proficiency in terms of work and active engagement in the workforce. But this, I think, is the most compelling thing, and that's the ethnicity of offenders. And the tall one at the left is Caucasian. So it's a rather broad label that's applied by the police. But if we think of white persons of some sort of European origin, Caucasian predominate among the offenders. The next one is Mediterranean, Indigenous, which happens to actually match the proportion that we'd expect from the census population data. Asian, Middle Eastern, Hispanic, and a number were missing. But I think overwhelmingly we are looking at this issue of Caucasian offenders, and that brings to mind a question: why do we not see other ethnicities involved in the offending that we're detecting in this particular cohort? Well, there might be lots of reasons for that. The question is whether other ethnicities are not offending, or they're offending in ways that we're not detecting. I wanted just to pursue the ethnicity issue because it is rather compelling too to consider the ethnicity shown in images, which was some information obtained by the police for at least 68 offenders, showing the ethnicity of victims and perpetrators. And what I would like you to consider are the two columns to the left: Caucasian and Asian. So Caucasian victims and Asian victims, and Caucasian offenders and Asian offenders shown in the pictures, so perpetrators in the images. So what that's telling me is that with the predominant population within this cohort of people being Caucasian, where we find Asian perpetrators in images, that fits a particular realm of seeking child exploitation material online, and that is to have other people perform acts on your behalf with children in other places. And there is information from this particular study that shows that on-demand sexual exploitation by people in Asian countries was figuring in the cohort of offenders in their offending. So we have that to consider. The other ethnicities that are significant is the next one, which is the third one along, Eastern European. And we know that Eastern European countries supply a lot of the commercial trade in SEM. I don't know whether we need to go on, but the Mediterranean, Hispanic, African, Pacific Islanders, I suppose we would be interested in that in terms of whether, if further investigation of that indicated Australian offenders offending in the Pacific and seeking images from the Pacific, because we do know that that's a profile of contact offending, people who do go to Pacific Island nations as Australians for the purposes of overseas child sexual exploitation. So I think there's a lot to be done in terms of further study about ethnicity in images, but we had limited information in terms of these 68 offenders. It is important to consider the idea of the severity of images. By the way, I should have said at the outset, I don't do image research, and there will be no images shown in this presentation, obviously, but just to make sure that I've said that. This project does not involve image research. But I have a lot to say about images because the need for people to look at images is a very worrying prospect in terms of law enforcement and what happens when cases come to court. So a very odd process that we still have people looking at images of child sexual exploitation for legal purposes without a lot of thought about whether there might be other ways to do that. So the use of automated procedures and scales that are clear and coherent might be useful in that regard. The Copine scale, and we have someone here in the audience who's written about the Copine scale and the need for it to be properly validated, so that's Professor Douglas Bohr. He's written on that topic. It is a scale which is there for psychologists. It was picked up and used as part of the Oliver scale in a United Kingdom case of Oliver, where it was reduced to those matters that were the most serious among the ways in which people might engage with images of children in a sexual way. So it begins with sexual posing in the Oliver scale, right up to child sexual assault or bestiality, so the most extreme forms of graphic abuse of children that you could consider. The SET scale comes from Microsoft, and it's the tracking scheme for child exploitation images, That's used by Australian police, and it's to be migrated over or integrated with ANVIL, which is another acronym for another way of dealing with these schemes of categorising images, but it's all not quite in place yet in Australia. So we have quite a mixed view about how to categorise images. The difficulty I think that is presented is that the lowest grade, the least severe images, those of sexual posing, present, I would imagine, the greatest difficulty in terms of assessing whether they are offensive for the purposes of criminal sanction. It may be easier to determine if you included age of the child depicted, but age of the child depicted isn't part of these classification schemes, other than to say for a Commonwealth offence the person needs to be under 18, and for state and territory offences that they need to be under 16, being the age of consent for sexual relations. So the Commonwealth provisions stand out a little bit in terms of creating this additional uncertainty about age. In any event, the 2014 UK Sentencing Council issued new guidelines which overrule the Oliver scale and its application. They actually set up a scheme where they say, well, we should start talking about the most severe first, so that's A, going to the least severe, which is C. And they've basically collapsed the old scale from Oliver into an ABC scale, but they're giving emphasis to, firstly, the most severe images. But interestingly, for Australian jurisprudence, they have suggested that when you go to sentence somebody for an image collection, then if they have a small proportion of more severe images in a larger collection, it is suggested that you might disregard the smaller number of images. Now, I think that's highly problematic in terms of a person then just deciding, well, I will hide or obscure my engagement with a particular form of severe image just by having lots of other images. So it's a pretty clumsy way of approaching the task. What it does suggest, though, is the need for much greater work on how we might come up with a calculus to think about the degree of offender engagement with images and what that actually means. So let's talk about the nature of the images. I'm not going to do that now, but that's the open discussion that needs to be had. What is actually depicted? What ages are depicted? The quantity is, I think, almost meaningless as an indicator. Because if you have a video file, it might have many, many thousands of still images that you could pick out of it. So how do you quantify that? And it's a particular problem in terms of our study, because there was not a consistent methodology for counting the number of images. And so that's a thing that is, I think, an imperative for a standardised form for presentation, particularly in court. When you're sentencing people and you think that quantity is important, you ought to at least have a consistent way of measuring that. And more importantly, we might need to be thinking about how offenders use the images. Well, offenders don't normally tell us much about what they do because they don't have to tell us anything, and there's a right to silence. People say they collect images. People will say that they were interested in a particular series, or that they were compulsive in their behaviour. Very few open up and say, well, I take the image, I put it on my screen and I masturbate to it. But presumably that is part of the activity of people. So we need to think, well, what do we know about how people are engaging with images, and what aspects of that are significant, and how long have they held the images? That might also be important. Where did they obtain the images? Are they images they created themselves? Have they directly encouraged the sexual abuse of a child in Asia, for example, or in the Pacific, in order to have particular images for their own gratification? So those issues really don't get well quantified or analysed in the sentencing of offenders. And we have this problem: who gets caught? And what can we prove? So we find that in this particular study, we have people who are caught for Commonwealth offences. So we've got a view that's based on people who are actively engaging online, and somehow they get detected for that. And the method of detection is usually by some other government agency for the Commonwealth in this particular instance. And that could well be to do with the setup of this particular unit, in that they're receiving the notifications from overseas agencies. And so we have a channeling or coalescing of particular forms of abuse, and I can hardly say that this is representative of all of the abuse that occurs through the use of child exploitation material. The police have the other problem of what they can prove once they've executed a search warrant. They might know that there has been a lot of traffic on the internet for a person, but they may not be able to prove all of it because of things such as the use of encryption, people who delete the material as soon as they've looked at it, lots of things that are explained in the report in terms of how people approach their offending, where it's sometimes difficult to know truly what they've been using and how much material they've been using, but you've got a pretty good idea that they've been using a lot more than you can prove. Again, of course, because it's the Commonwealth offences that we're looking at, it will only be those images that are related to the use of a carriage service that are part of the process of taking that person to court and having them convicted. They can only be convicted for those matters as a Commonwealth matter that are to do with the electronic communication, because that's the jurisdictional constraint of the Commonwealth. It doesn't have general powers over criminal law, but it does have power over telecommunications. So there's that issue of really when we're talking about what is discovered for the purposes of law enforcement, what does that really mean? It's worth pursuing this further though, and for the police to continue to record data and to analyse it. This is valuable research, I'd suggest to you, because similar work done by Long and others in the United Kingdom, Matthew Long works with the UK Police and is a psychologist by training, they had a study of over 100 offenders and their image collections, and they found a significant association between the size and content of those collections and the degree to which a person was involved in contact offending. So I think this is a valuable area for further study. Unfortunately, the way in which the data was kept for the AFP material that we were looking at, we probably won't be able to replicate the analysis done by Long. But it does suggest that we ought to work more in that area, particularly we need to move away from Commonwealth offenders, looking at those who are caught as part of state and territory policing operations, because state and territory police will principally be the persons or the agencies responsible for the first time investigation of contact offenders. So we really want to know more about contact offenders who become SEM offenders or SEM offenders who become contact offenders. What I can say about our current study is that networking and networking roles were significantly related to contact offending or grooming offending. So I think that gets to the point about how do people use material, how are they engaging with that material, and how is that working out with other people who might encourage their offending, who might create additional demands for material, but create an environment in any event where the SEM is normalised, if not encouraged, if not actually made a commodity that's of value either economically or in terms of importance within the network. So really the question I have is, how do we assess risk, which is obviously the topic of this whole talk. seems to me the risk of reoffending is important. Sem reoffending is if we look at the work of Long and if we look at the idea of network behaviour being indicative of likelihood of being involved in contact offending, a continuous engagement with SEM, I would suggest to you, is something that we need to consider as a possible risk factor for contact offending. I'm not saying it is, I just think that there's information there that's worth exploring. The escalation of offending is something else that we need to be looking for evidence of. There's a likelihood, I would suggest, if we thought about the 3 or 4 ages of offending, that escalation of offending is more likely for those who have grown up with digital technology. For them, it's ubiquitous. I would draw a parallel with the ADFA scandal in terms of Skyping sexual intercourse images. So it's not child sexual abuse or exploitation, but where there is a idea or a phenomenon that's become common of filming that sort of activity and then showing it to other people, which I suggest to you was the case prior to the ADFA incident. You need to think, well, how is that forming and shaping the behaviour of people? Because the ADFA incident suggests that people in all sorts of situations and under all sorts of different command and discipline structures might become involved in that sort of activity. So how do we deal with it? And I then ask us to think, well, if that's what might happen in terms of adult sexual activity, on how it might become part of some sort of digital behaviour, might there be similar sorts of problems and issues arising for young people who live within a digital milieu already? And where might they end up in terms of their offending? Against that, I wouldn't want to be creating a sense of moral panic about this, because I would be wanting to also ensure that children had their own capacity to explore their own sexuality on their own terms. So that's a difficult and thorny issue about what do you do about sexting, for example. Is that okay, or should it be regulated, or should it be a criminal offence? And indeed it is a criminal offence in some jurisdictions, in certain circumstances. So we need to consider where we go from here. The sentencing questions that we need to have a better handle on are, how do we assess the gravity of offending? And I hope that I've laid some groundwork for thinking about engagement and the way in which people deal with their images or use their images in a network is worth considering. Currently, the courts follow a demand reduction rationale. You find it as a consistent theme in child exploitation material offending sentencing, that the judges talk about the need to stop this problem, and the way to stop this problem is to deal with all offenders with equal severity. That seems to be the idea. Doesn't always happen. And there is a whole suite of cases to be examined where people are dealt with summarily for these sorts of offences and receive lighter penalties than you might otherwise think might be applicable for child sexual exploitation material. Why is that so? I mean, that's an important question to have answered. And similarly, people who are sentenced for child exploitation material possession, around the globe we've seen changes in judicial behaviour in terms of a community expectation that people be dealt with severely, but when the cases are analysed by the people who have to sentence, they deviate from recommendations for more severe penalty structures. So I'm drawing on the work of the United States Sentencing Commission, which undertook a detailed study of the problem of they call it child pornography there, child pornography offending and the way in which people were sentenced, because there was a great deal of deviation from the mandatory standards that had been set in the United States. What is happening in that context is that once you start looking at the cases, the range of offending that's actually involved under the heading is so broad that there is perhaps good reason for deviation from mandatory sentencing principles. And equally in Australia, where we do not have mandatory sentencing principles, but the courts still speak of the demand reduction rationale, that we need to be severe in our penalties for these sorts of offences because we're trying to stamp it out, we might actually have to think whether that's truly going to be effective and whether in fact it might be counterproductive. If we thought about the war on drugs, for example, the counterproductive aspect might be, where do people with a problem about SEM engagement go to get help? Because that's not recognised currently in the law. That is a major problem. And to my mind, the demand reduction rationale simply doesn't work because the demand keeps growing. And why people think they can get away with it, perhaps it's because they feel that in the digital environment they can't be discovered. Maybe more people will be more concerned about their digital behaviour with 2-year record keeping of metadata. Who knows? I don't think offenders probably think about that. So, issues in summary. We had a small lens. It's important to work on these definitional problems. It's important to keep amassing data and keeping good detailed data about the nature of offending and trying to standardise that so we can get a common approach and common understanding, and continue to work on the question of risk and prevalence and effectiveness, the effect of what people do and the effectiveness of our actions in trying to combat child exploitation material. The prevalence thing I've put up there because given that this current study is about Commonwealth offending, there's a real need to add what's happening in terms of state and territory offender profiling. So to move that along, I'm just reporting that I'm currently engaged in a study with Boxar, it's very early stages, but to look at the criminal trajectories of people and pick out child exploitation material offending as the index offence and then start to look at their criminal careers and compare those with those who are child sexual exploitation offenders but who do not have child exploitation material offences on their record. I'm doing a study with the New South Wales Police on online grooming, and that is, I can talk generally a little bit about that. That's a chat log analysis it was meant to be, but interestingly in the information provided by the police is a great wealth of data about what police have in terms of intelligence information about potential offenders. And the courts don't see that in terms of sentencing. And it arises, for me, gives rise to a question about, well, how can we usefully use that sort of intelligence information in a more structured and helpful way in terms of dealing with offenders? In any event, that's ongoing research. And I'm about to embark on a study with Queensland Police on peer-to-peer network behaviour, because there was some peer-to-peer networked behaviour in the current study, but most of the offending was done on the open internet, on the web. It wasn't really a study of peer-to-peer network behaviour. These are people who are caught out in terms of what's observed often in international police operations of people who are online networking or accessing sites where material is openly exchanged. So I'm thinking that it might be great to have an aggregated study across Australia about this problem, create an evidence base for assessing risk and the prospects of rehabilitation, and continue to make international comparisons. Now, I'm not able to tell you at this stage the precise figures for our study in terms of what the Americans called precidivism, prior offending, for our cohort. But let me say that it fits within the range of these studies that were reviewed by the United States Sentencing Commission in their child pornography reference. So 33% contact child sexual, criminal sexually dangerous behaviour. So they had a very strange term that they used with very broad compass that includes behaviour, so it includes things that have not actually ended in convictions. So it gives you a high rate of recidivism or prior offending because they're actually looking at more than what people get convicted of. So not unnaturally, our figure falls under the range of what was found by the US Sentencing Commission, but I'm just not allowed to say what it is at the moment. But there, you see there are various studies with different numbers of cohorts. The US Sentencing Commission studies were showing, because they have this broad view of what might be considered prior offending, including things that you haven't been convicted of, roughly 33%. CETO, working in Canada doing a meta-analysis, came up with a 17% prior offending rate. And that's just general offending, it's not specific, that's offending there for his study that is involving convictions. So that makes the distinction between what the US Sentencing Commission was considering and what CETO was looking at was actual convictions. So post-offending, again, I can't actually say precisely what we found, but we're again within the range of these studies in terms of what you see in the fifth column, general offending, reoffending, all sexual reoffending and contact sexual reoffending. So that probably is consistent too with what we saw in terms of the dimensions of the cohort, that we had so many who were solely arrested for SEM matters and those who were involved in grooming offences alone, those who were involved in SEM and grooming, and those who were involved in SEM and contact offending. So I'll leave it for you to obtain the report when it's released to see the detail of that. One of the reservations we have about giving details of that now without the report in your hands is the need to see the context and to see the explanations that go with the particular rate that's described. But the small lens gives us some view, but it doesn't give us the whole view. And there is a danger too of looking at a particular study and saying, well, that shows that SEM offenders are all of a particular type. And clearly we cannot say that from any of the studies that have been undertaken so far. Thank you.